admission of new evidence. They are in two broad areas as follows. One, would the evidence, if it had been presented during the trial, have had any influence on the result? Two, could the evidence have been obtained before or during the trial by the exercise of reasonable diligence? The review jurisdiction of the Supreme Court is properly invoked under Rule 54 of the Supreme Court Rules 1996 CI 16 and requires the satisfaction of two grounds. A. Exceptional circumstances which have resulted in miscarriage of justice. B. Discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not be produced by him at the time that the decision was given. Counsel for petitioner has asserted that it amounts to a fundamental error for this court to A. Fail to find that the first respondent depositions about being available for cross-examination should be conclusively presumed against her, such that she should be compelled to testify as a witness of the petitioner. He urges that this failure to properly construe Section 26 of NRCD 323 is a fundamental error of law. He also urges that this court's construction of adverse witness by relying on the definition contained in Black's Law Dictionary instead of Section 72 of evidence that constitutes another fundamental error. Third, he urges that by dismissing the petitioner's application to reopen his case for the sole purpose of calling the electoral commissioner as a witness of the petitioner, this court is shielding her and enabling her to evade cross-examination, contrary to a position she had deposed to earlier in the processes in this petition. It is the position of counsel for petitioner that the chairperson of first respondent is required to appear and testify to the truth of what happened in the election in dispute to account to the people of Ghana for her stewardship as the returning officer of the presidential election, for which she had issued a first declaration and corrected that declaration with a press release the next day. She was also required to clarify matters arising during the cross-examination of the petitioner's witnesses. We disagree with counsel for the petitioner on all these grounds, urging alleged fundamental errors as constituting exceptional circumstances. This is a court of law and not a forum for suppositions. It must be stated that courts of law administer justice in accordance with law and settled practice, and no court can afford to lose sight of this. Further, this is the highest and the last court of the land, and our decisions on the questions of law have binding effect on no other courts. That before this court accedes to any application that is not covered by statute, the rules of court, or known general principles of law applicable in this jurisdiction, this court must ensure that it's not opening a Pandora box that can become a stepping stone for abuse of court processes at other levels of the judicial system. The interest of justice is not only the interest of one party in the dispute, but must necessarily be an outcome arrived at through the proper balance of what the law has prescribed as the duties of the court to all parties and the duties of the parties to each other. Thus, when the court has to exercise its discretion in an extraordinary situation, such as a party seeking to reopen his case after all parties have closed their cases, the court has to ensure that the discretion is consistent with statute, rules regulating procedure, principles of law, and settled practice of the courts. We have earlier in this ruling set out the guidelines that all courts must follow when determining applications for leave to reopen a party's case at any time after they had voluntarily closed their own case. Applicant has urged that this court failed to appreciate the import of Section 26 of the Evidence Act, NRCD 323. This submission is misconceived because we fully appreciated the submission of the petitioner's counsel and found them wholly unsupported by any rule of law or rule of equity to which the conclusive presumptions is made subject. It is not the case, as urged by counsel for petitioner, that we allowed Order 38 Rule 3E5 of CI 47 as amended by CI 87 to take precedence over a substantive act of parliament. The Supreme Court reviewed the legal principles on the equitable doctrine of promissory estoppel that has been captured in Section 26 of the Evidence Act in the case of Clipper Leasing Corporation versus AG and Ghana Airways in liquidation, 2016, 100 GM 1 Supreme Court. The holding of the court clarifies that for a statement to constitute conclusive presumption, it must be a statement of fact, and it must be clear, unequivocal, unambiguous, and unconditional. The promisor must have intended the promisee to act upon it, and the promisee must show that he acted on it and altered his position. Further, all the circumstances of the case will be taken into account in granting relief, and the usual maxims of equity will apply. From this premise, the first question to ask when a party alleges that a statement must be conclusively presumed against the maker of the statement is, was the promise clear, unequivocal, unambiguous, and unconditional? Was the promise and the context of the promise such that the promisor intended the promisee to act upon it? Did the promisee show that he acted on it and altered his position? In the context of the case before us, we are satisfied that the depositions in issue cannot satisfy the minimum threshold of being clear, unequivocal, unambiguous, and unconditional undertakings of the first respondent herein to defend itself in this suit. At the time the depositions were made, the first respondent had already given notice in its answer that it considered the suit as disclosing no reasonable course of action and had gone on to file its submissions with respect to that position. All three parties had filed their submissions on this point. We found this to be the most determinative factor, that these depositions cannot be construed as clear and unambiguous undertakings that could give rise to a conclusive presumption that the first respondent will be defending itself in this suit. Again, the depositions were made by the chairperson of the first respondent as a representative of a party in this suit, and not in her personal capacity as a party in the suit. The decision whether or not to testify in the suit could only be that of the commission and not hers. The decision whether or not to personally testify on behalf of the first respondent commission is also not available to the chairperson because he is not a party to this suit. Further, cross-examination is only possible if there is examination in chief. Thus, if the first respondent, which is an organization, decided after the petitioner closed his case not to defend itself, the statements made as part of an affidavit in opposition indicating the options the petitioner could exercise if the interrogatories and other applications were disallowed cannot be said to have been unambiguous undertakings to submit either the commission through the chairperson or any other officer to cross-examination in a suit that it had not offered testimony in chief. Counsel for applicant has also urged that this court failed to consider Section 72 of the Evidence Act, but rather relied on the definition in Black Law's Dictionary, and so the ruling under review was per incuriam. We find no merit in this submission. Black's Law Dictionary is a respected and reputable source book for the bench and legal practitioners. Reference to law dictionaries is an accepted and respectable practice in common law jurisdictions, including Ghana. Furthermore, there is no inconsistency and contradiction between the definition in Black's Law Dictionary and Section 72 of the Evidence Act, as already determined by the Supreme Court. In Okan disease, Dodu and another, versus Okan and others, 2003-2004, 1 Supreme Court of Ghana Law Report, page 582. We are certified that it is the nature of testimony proffered by a witness that allows a court to categorize that witness as an adverse witness or hostile witness, and not the description of the witness as such. And so the submission that the witness was to testify as an adverse witness was no answer to the need to clarify the objective of seeking leave to reopen the case and call the chairperson or the first respondent as a witness of the petitioner. Section 72 of the Evidence Act provides 72(1). Subject to the discretion of the court, in a civil action, a party or a person whose relationship to a party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. When such a witness is cross-examined by his own lawyer or by a party who is not adverse to the party with whom the witness is related, that examination is to be treated as if it was a re-examination. Clearly, the positive part of the provision in Section 72(1) is the fact that the person who calls such a witness has an interest that is adverse to that of the witness, and he is allowed to cross-examine the party he has called, and not that he merely described the witness as an adverse witness on the application to call the witness. In Ray Okan disease, Dodo and another versus Okan and others, Supra, the Supreme Court had the opportunity to review the distinction between an adverse witness and hostile witness. The court was clear that being an adverse or hostile does not arise from the description given by the party who called the witness, but the nature of testimony given by the witness. First, Dr. Sechu JNC had this to say in clarification on the general nature of witnesses and the specific nature of adverse and hostile witnesses at page 599. Quote, as a result of the testimony of the third plaintiff witness, namely that he did not see either the testator or the second plaintiff witness sign the will, counsel for the executors applied for permission to treat him as a hostile witness. Learned counsel for the defendants was right when he submitted that the witness should be rather treated as adverse witness and not as a hostile one. The reason is that any attesting witness will be a witness of the court and not that of the party calling him. End of quote. Professor Kluje JSC went on to state as follows from page 626 in his evaluation of when the witness is an adverse or hostile witness and the effect of the testimonies of the two types of witnesses. Quote, the trial judge, with the benefit of observing the witness, may choose to believe an adverse witness or part of his testimony. The fact that a witness called by a party gives an adverse or contradictory testimony does not lead to the irresistible conclusion that the adverse witness is an untruthful witness. The witness may be an adverse witness precisely because he insists on telling the truth rather than commit perjury in support of the fabricated story of the party who called him. Usually, it is difficult to determine whether the witness is merely adverse or hostile when there is no previous statement by him with which he could be confronted. In my view, a witness is a hostile witness if it can be shown that he knows the truth but deliberately persists in lying to the court. There may be different ways of arriving at that decision. End of quote. We do not see any fundamental error or question by this court's evaluation of whether the chairperson will be an adverse witness merely by her description as such by counsel for petitioner, even before she brings any testimony to the court. The issue that was determined by the ordinary bench is whether it is proper for the court to exercise judicial discretion and allow the petitioner to reopen his case for the sole purpose of calling the chairperson of the first respondent as his witness by the issue of his subpoena. Our determination was that it would not be a proper exercise of judicial discretion, and we do not see the miscarriage of justice that our decision occasioned, since petitioner continues to insist on not disclosing what new material the proposed witness is to testify on, and how that new evidence can change a judgment that is yet to be given. Counsel for petitioner also contends that the ruling was in breach of Articles 19, Clause 13, and 296, as it was unreasonable and irrational. Counsel for petitioner failed to draw the court's attention to any unfair exercise of judicial discretion exhibited by the Supreme Court against the petitioner, just because the court refused his application to reopen the case he had closed and to serve a subpoena on the EC to serve as an adverse witness. We would like to reiterate a time-honored principle of the adversarial system we operate, quoting the Supreme Court in Clipper leasing case. Again, quote, the well-known policy of the law is that parties to a case in court are to know exactly what is that they are required to answer, and this is a requirement of fair hearing that the courts insist on. The requirement of fair hearing is a fundamental rule of natural justice, so a party cannot change its case on appeal when the opponent has no opportunity to adequately defend himself and lead requisite evidence in his or her defense. The petitioner purported to present his full case in the witness statement submitted after the depositions in issue had been made. On the strength of those testimonies, including that of a third witness petitioner later called, respondents closed their respective cases. If the petitioner intended to rely on the depositions in issue, The law required him to state as part of the testimonies he would rely on the specific testimonies or documents he wanted the chairperson of the first respondent that petitioner has summoned before us to produce to aid the petitioner's case on the alleged strength of the depositions. As part of pre-trial processes, the parties and this court could have had the opportunity to tell me if truly the documents were not available in petitioner's custody, as happened in the application to produce originals of the polling station results, or the testimony sought was relevant to the settlement of the matters in controversy in this petition, as happened in the application to serve interrogatories. Statutes are construed and applied as a whole. No party or court may take part of a law and urge it to be applicable while ignoring the rest of the statute. Sections 10 to 14 of the Evidence Act lays down the burden of producing evidence and the burden of persuasion squarely on the party that alleges any position of fact or issue of law. Further, we stick to the time-honored principles that the Supreme Court has adopted in circumstances in which it reviews its decisions. Thus, in the case of Mechanical Lloyd Assembly Plant versus Nati, 1987-88 Ghana Law Report 598, page 603 to 604, under DJS stated, quote, "Let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer, along with the evidence grounding it, can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision would be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. The review jurisdiction is a special jurisdiction to be exercised in exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in exceptional situations when a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor is it an automatic next step from appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. Secondly, in Chapel Hill versus Attorney General and another 2010 Supreme Court of Ghana report, page 827 at 850, the Tiban JSC further set out the parameters for reviews as follows. Quote, "I do not consider that this case deserves any lengthy treatment. I think that it represents a classic case of a losing party seeking to re-argue its appeal under the garb of a review application. It is important that this court should set its face against such endeavor in order to protect the integrity of the review process. This court has retreated several times without number that the review jurisdiction of this court is not an appellate jurisdiction, but a special one. Accordingly, an issue of law that has been canvassed before a bench of 5 and on which the court has made a determination cannot be revisited in a review application simply because the losing party does not agree with the determination. This, unfortunately, is the substance that the current application before this court is." End of quote. The application and the review was dismissed because it was not based on any known law or rules of practice. We dismiss the instant application as being wholly without merit.
As the court pleases. You are grateful to the court.
Yes, we are most grateful.
Yeah.
The panel will be reconstituted. All rise.
May it please your lordships, I appear for the petitioner with me, the petitioner applicant with me, my learned friend Tony Later. May it please my lords, Justin Amenuvo appears for the first respondent with me, Alexander Somoa Samoa.
If it pleases your lordships, I put on power for the second respondent. My lords, with me are my learned friends Frank Davis, Kwekwe Sirifi, and Yao Pong.
My lords, we have before you two applications, one of which we've indicated we are withdrawing them. There's an application for stay of proceedings pending the review. The review has been disposed of, and we do not intend any further steps in relation to that application. We have an application for leave to file our closing address after the date that your lordships ordered, and in the affidavit in support, we've indicated also that we are withdrawing the motion for stay. Yes, my lord. Lords, as regards the motion for stay, I have no objection to it being withdrawn.
My lords, the same.
By court, the motion for stay of proceedings is struck out as withdrawn.
Most grateful.
Yes.
My lords, I move the motion for leave to file our address after the date ordered by the court. I move that applications in terms of the motion paper and the supporting affidavit. And my lords, as we've indicated, the affidavit in support is sworn to by counsel in this particular case for obvious reasons that appear on the face of it. My lords, we are opposed to the application. We are opposed to the application, and we are opposing it by virtue of Rule 69C of CI 99, and also, my lords, by reference to the case of Republic versus High Court, Tamale, ex parte Dakem Zobuguna Henry Kalim, civil motion number J5/6/2015, judgment of the Supreme Court dated 4th June 2015. Lords, in that case it was held that the bare fact that an application for stay of proceedings has been filed does not operate as an automatic stay. So no party
has the privilege to stay away from proceedings as the applicant did at the court below. Lords, if we look at the affidavit in support, the applicant or the petitioner is brazenly telling the court the reasons why he has refused to comply with the orders of the court. When established practice and the decision of this court is that the mere filing of a stay does not amount or give you the right to stay away from proceedings, because this is the highest court of the land, and I think that obeisance to the rules and orders of the court are part of our practice. And insofar as the depositions clearly show that yes, I chose not to comply with the orders for my own reasons, I pray that this application be refused. Your Ladyship, 69C of CI 16 as amended by CI 99. Yes. The 4B, Your Ladyship, with your kind permission, the court may dismiss the petition where the petitioner fails to file the processes regarding the petition within the specified time. Laws.
No, but we've had the case to conclusion.
Pardon?
I said we've had the case to finality. We are left with only closing addresses.
Yes, my lord, it's part of the processes that we file.
My lords, we are opposed to this application to the extent that the petitioner is not seeking the magnanimity of the court.
But what is he seeking?
He is asserting a right. My lords, the petitioner, my lords,
yeah.
If your lords would refer to paragraphs 10, paragraphs 13, paragraphs 15, and paragraphs 14 of the petition. My lords, of the affidavit in support. My lords, the petitioner is seeking to tell the court what is convenient for it. So it says in paragraph 10, it would not be ideal for me to have to file a closing address without the testimony of the chairperson. In other words, the court has directed him on the 11th of February that we should all file closing addresses by the 17th. And he elects to tell the court that it will not be ideal for him to file, to comply with the court's order. On what basis can a party tell a court much more the highest court of the land?
It's coming from a friend on the other side. No, it's coming from my lord. That's the position in the affidavit you are referring to.
Yes. So, my lord, I'm saying that this deposition is a direct defiance of the court's order.
For leave to file,
but it's in the leave, in the application for leave, is an example of the defiance. My lord, that's what I'm saying. That it is one thing for them to come to this court contrite, and therefore the court should grant their leave. But they are trying to justify what they did, their defiance of the court's order. So, my lords, they may be advised to withdraw those paragraphs, offending paragraphs, and just plead to the court that they be granted leave. But this attempt to justify the unjustifiable.
So, preparing the only the decisions, who seeks to assert a right?
Yes. because the application is based on the depositions. So they may choose to advise themselves and withdraw those depositions, of offending depositions. So that, because my lords, if this court grants this application on this basis, it will set a precedent. It will undermine the court's well-established authority that a review application is not a stay of proceedings. Secondly, that a party who files an application for stay is not entitled to stay until the court grants it. Those are two very important, principles of this court. And if the court grants this application based on these depositions, it will be undermining those principles. So our view is that it's all fair for the court to grant the applications, but it cannot be based on these depositions. No, it cannot be. And finally, my lords, they have arrogated to themselves the proposal of when they file. No, yes, I know that will be left to the courts. But, my lords, will you hear me out? They have already had, since the 17th, since the 11th, now it's about how many days? 11 days. And they're asking for a further 72 hours. Meanwhile, we, under pressure, have met the court's order. So if they are seeking the court's leave, they should be filing this thing either by the end of the day or latest tomorrow, my lords, because they have indicated to your lordships that they already have a draft. Yes, but my lord, again, like their samples, they are saying this is a draft, so that it will give them the opportunity to go and produce something completely different from the draft.
Order in court, please. Order.
My lords, I will not dignify some of the comments on our conduct. My lord, there have been very serious comments made about our conduct, which I will not dignify with a response. I will not dignify them with a response, because saying that we filed something and then we'll go, I mean, these are serious allegations, but I do not wish to dignify them with a response. That's what I wish to say. I only wish to say respectfully that we have come to this court asking for leave. And in indicating that we are seeking leave, we have adverted in our affidavit to certain factual realities that we have had to deal with. Those factual realities include the fact that we have filed applications for review before this court. Those applications have been heard by this court and they have been dismissed. But we could not have contemplated that those applications would necessarily be dismissed, because we did not believe that there were predetermined outcomes for those applications. That was not the basis on which we proceeded. We did not believe that. And because we did not believe that, we took our time to deal with those review matters in the hope that after the review, we might have the chance to have a witness testify. The court has this morning decided, or this afternoon, the court has this afternoon
my
decided.
lords, with all due respect, my lords, he can respond on points of law at this stage. No, please, my lord, that is the process I mean. Please,
if the bench wants to say something, you defer to the bench, please.
Very well,
Mr. Contempt, before he could move the application formally, I had wanted to know whether any of you were opposing it. It is normally done in practice just to, as to manage time. So, well, I anticipated that, well, this is a colleague on the other side who has sworn to an affidavit explaining his inability to do that. He has annexed a proposed, normally we call it a proposed, not a draft, a proposed statement of case or whatever. So I thought that you were not going to oppose. That was why I cut him short and decided to ask whether you were opposing it or not. It is normally done.
Very well, my lord.
Yeah.
And my lords, in the affidavit in support, these clear circumstances in which we have found ourselves have been put before you. As a matter of fact, the paragraph 10 that counsel for the second respondent found so offensive. My lord, with respect, there is no offense to this court in the lawyer saying it would not be ideal for me to file a closing address without the testimony of the chairperson and then have to file a separate further component of should the review application be submitted. That is a very simple statement of the reality that we find ourselves in. So rather than get into all these things, we have given an indication to the court, and we say in paragraph 13, the deponent says in paragraph 13, I will crave the indulgence of the court to allow. We did not arrogate to ourselves a time frame. The position is very clear. I will crave the indulgence to allow, and this just gives an indication to the court of a time frame within which it will be feasible to file. How can anybody interpret paragraph 13 as imposing on the court or as not being, as not recognizing what the court's authority in this? The very heading of the application is motion for leave to file, and therefore we do not see any problem. But my lords, fundamentally, we respectfully say, as in paragraph 15 of the affidavit, there will be no prejudice to the respondent by the grant of this application, especially as they ultimately elected not to adduce evidence in support of their case. So, my lords, we have not had sight of whatever they filed anyway, because I believe the registrar may have been under some instruction, but the registrar did notify us when he was serving other processes that that particular process had been filed but not served. That was notified, and we have not sought to have that because we don't need it. Our legal arguments are not premised on what they have said. Our legal arguments are very clear. And your lordships may note that we call it a draft, my lords, for a very specific reason. Because it is not, as is clear on its face, it is not yet complete. It is very clear it is not complete. In fact, there are gaps in places where certain things are meant to be included. It's very clear. And so, my lords, we've indicated there's a draft, and we've indicated a potential time frame within which the lordships may be willing to grant us the indulgence of filing. And therefore, we respectfully seek the indulgence that we have asked for in our application to enable us to file our closing address. And my lords, may I finally say that when we stand here at the bar, we stand here as officers of the court. We stand here as officers of the court seeking to help the court advance the interests of justice. And in that regard, I believe that a closing address that presents to the court the case of the petitioner in its entirety is something that will be beneficial in the interest of justice.
Mr. Chikata, how do you reconcile this prayer that you are now making to the earlier statement which you made when you were on your feet, that you did not know that there were predetermined outcomes? I heard you clearly.
No,
Mr. Chikata, Mr. Chikata, can you listen to me? When there is intervention from the bench, you have to listen. That is a practice we know from the bar. I heard you. I may not have heard clearly. But what I heard is what I'm asking. Now, how do you reconcile this with the earlier statement that you made, that you did not know that there were predetermined outcomes to the applications that you had filed? That was why you did not file your address.
Yes, my lords, what I
did you say that there were predetermined outcomes?
My lords, no, I did not say it in the terms that you have put it. What I said was that when we made our application for review, we expected that application to be successful. We did not know that there would be a certain outcome. And my lords, we can plead and
Mr. Chikata,
but my lord,
you use the word predetermined.
Yes, my lords, I use the word in the context
if you can explain.
Yes, my lords, I use a word in the context of stating that what the outcome of that was not known in advance by us. So it was not, in our minds, it was not a predetermined outcome. That's the point I was making. For us, it was not a predetermined outcome. That is the fact. And that is what I said. That is what I said. And I believe your lordship has just indicated that that's how you understood what I said. And if your lordship understood it differently, that's certainly not my intent. I stated clearly that for us, it was not a predetermined outcome. And so we could not have, on that basis, prepared a closing address without reference to the potential of that witness being called. We could not have done that. That's a clear indication. And my lords, I mean,
by court. We are of the opinion that the petitioner should be granted leave to file his closing address on or before the close of Tuesday, the 23rd of February 2021, in the interest of justice. Yes. Yeah.
We're grateful.
Yeah. Yes. The petition is adjourned to the 4th of March 2021 for judgment.
My lords, I was actually going to make a preliminary before your adjournment. Is it possible that I may be heard on? Because my lords, in terms of the filing of the addresses,
yes,
I was going to respectfully draw your lordship's attention to the fact that there had been an earlier indication that you would provide a time
for you
oral highlights of my lords. May I respectfully finish? That time has passed. I'm aware of that. But my lords, in the light of the new orders, I was going to respectfully ask that after we have filed our written address, an opportunity may be available for your lordships to seek any. My lords, in the petition of 2013, there was an opportunity provided which enabled certain important legal issues that had been raised in the written addresses to be addressed by the bench and the counsel on both sides. And my lord, I believe that even if it's for a half hour, as the timekeeper has been rigorously insisting, that enables
Mr. Jigata, we have indicated that we are adjourning for judgment. Now, if we, upon reading your closing addresses, think we want some clarifications, we may come to you. But otherwise, we have adjourned for judgment. Very well.
Order in court. Order, please. Lords, writ number J1/5/2021, Article 64 of the Constitution and Supreme Court Rules 1996 CI 16.
My lords, I take it that you are done with our matters. Very well.
As amended by.
There is a contempt proceedings which the court
as amended by CI 74 and CI 99. Amended presidential election petition. Presidential election held on 7 December 2020. John Dramani Mahama versus Electoral Commission of Ghana. Nana Adudankwa Akufo-Addo. Dr. Dominic Akurutinge Ayeni. Contempt. Lord, Contempt present.
Oh, please, yes. Are you represented?
Yes, my lord.
Council, may you respectfully announce yourself?
Frank Beecham appears for the contempt with Courtroom and David Beecham.
Yes. Miss Ayene. Sorry. Honorable Dr. Ayene. Please, you have been summoned here by this court to show cause why you should not be committed for contempt. Yes, because on the 16th of February 2021, we made certain statements which were very, very scandalous of the court.
Sorry.
Yes, we've exercised restraint in invoking our jurisdiction to always be committing people for contempt for obvious reasons. The other time, I think you were here when I drew the attention of Mr. Frank Davis. I think so also, yes, Lawyer Pong, then Marietta, the former learned Attorney General. I drew the attention and they stopped. But then, from nowhere, you also jumped onto the fray and you made certain scandalous statements which the bench thought that it was least expected of somebody who held a very high office as the leader of the bar when the Attorney General was not present. The Bar Association is just an association, but the Attorney General is the head of the bar. Yes, in every common law jurisdiction. So that is one of the enviable positions at the bar. Yes, I know the lead counsel was a president of the bar, but Attorney General, somebody who has acted as Attorney General, is the head of the bar, not the Bar Association president. And we want you to tell us whether you did say those words. Then you proceed from there.
My Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis, and Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
We have copies of the letter and we've circulated it. Yes, we are comfortable with the apology, but we want to make certain consequences of this. Yes, Mr. Beecham. Yes, you can be heard.
Yes, my Lord. With respect, our client has no excuse. Personally, as lead counsel for him, I was very disappointed at the article that I read last week and was deeply distressed when he called me last night. And I thought it was because I had made certain disparaging remarks expecting some action to stop this canker in the profession. It was to tell me that he had realized the error of his ways and pleaded for me to join him to render an unqualified apology to this court. He makes no excuses for that. He admits he is wrong and has been wrong. He deeply regrets the harm done to his profession, the disrespect shown to the court and to also to the country. I have his instructions to render his unqualified apology to every member of the Supreme Court and indeed the judiciary of Ghana and the legal profession and people of Ghana that he is awfully sorry for what he has done. He is deeply remorseful and he deeply regrets what he's done. So, my Lord, our prayer is, yes, true justice has to be done, but we ask you to temper justice with mercy.
You are a former president of the Donor Bar Association, is that right?
That is so, my Lord.
I have been worried for some time now, listening to people granting interviews to the media, and not any ordinary people or lawyers, but people who have occupied very high position in this country. And we have to decide where we want to go as a country. In my view, the only reason why Article 88 of the Constitution, or the only ministerial position which is provided for in the Constitution, is that of the Attorney General, is that when you are appointed an Attorney General, you are appointed an Attorney General for the whole country. A party or a president may appoint you as Attorney General, but once appointed, you are the Attorney General for the whole country. And you are to ensure that every citizen of the country is given justice or has access to justice and fair trial. So when I hear former Attorney Generals and Deputy Attorney Generals mount or grant interview and make certain statements aligning in no uncertain term to one political party, it's something that worries me. And as a former president of the bar, I think you have to open a debate in that area about the proper role of attorney generals or former attorney generals, having regard particularly to Article 88 of the Constitution 1992.
Man of respect.
Two lawyers to support you. What we can do for your client is to let him go back and purge the contempt. Yes, he spoke to the whole world on television. Yes, he should tell the people that he's very, very sorry. What he did was wrong, and that is all. We are not going to find him, we are not going to give him a bond, but at least coming from somebody who has acted an attorney general, if we don't take any action, it is going to send dangerous signals elsewhere. That is all what we want to do for him. So if he does it today, the court will assemble on Thursday and just strike out this matter. That is all. We are not exacting any serious punitive would I say measures against him. All what we want to do is for your client who has confessed to whatever he did to he just go and apologize for the harm that he has caused to the profession and to the bench. This is our profession. Nobody can come from elsewhere to make it better. Yes, beyond the lawyers, nobody can come from elsewhere to make it better. Yes, we can make it. And it is a duty which has been imposed on us by our call. Yes, so please, let's all cooperate. At times you hear some comments by lawyers and you feel that they are killing the profession, because a time will come when nobody will come and sit here as a judge. Yes, we posted one judge to ECOWAS court as a high court judge. He's not the president. Whereas the other countries posted their Supreme Court judges there. A high court judge from Ghana was the president there. But this is a something. We have the Court of Appeal judge here. He sought the leave of the Chief Justice to take outside appointment. He's the Chief Justice there. And no matter what we do, please, the profession first. Yes. the profession first, and we should endear ourselves to the respect and whatever it will take to bring the profession to its past glory. So we thank you very much for not dragging this matter and coming with an unqualified apology. So that is what the bench has decided. We don't want anything from the former Attorney General, Deputy Attorney General, but all what we want is the retraction, yes, an apology, yes, through the same medium, and that will end the matter. If he does it, we'll come here on Thursday and have it struck out.
Yes. We are very grateful to you for this indulgence, and also taking the cue from the point made by my Lord Amugati, whose views I share personally on a personal basis. And I did indicate to you why I stepped in, because I was even more worried when he called me. I thought somebody had accrued that I had made disparaging remarks about his comments, but that's the point. But the right to be done, Lord. And I am profoundly grateful for your indulgence, and promise you that even before we came here, we had started a process of showing remorse and regret. Most grateful, my lords.
I will say something soon, because Mr. Dr. Aine is a friend and a brother to me. I know he is a member of parliament and therefore a politician. But he should know how to talk when he is addressing the press as a lawyer, and then how to talk when he is addressing the press as a politician. There are two different things, because I know when politicians mount the witness box, they say anything, they can say anything at all. Then at the end of the day, when they are recorded, they come to deny. I've been a politician before. I know how it is. So you should know how to talk as a politician and then how to talk as a lawyer. They are different things altogether. Besides, we've been insulted, judges are insulted by people who know nothing about the law, and sometimes who know nothing about the issue that is before the judge. And they talk and insult. If they are not lawyers, we don't care. Because if you don't want to be insulted, you cannot be a judge. But if you are a lawyer and who knows the law and who knows the procedure, and then you talk, in a manner, that does not speak well of you as a lawyer, it gives opportunity to non-lawyers to also talk or say worse things. So that's my advice to him as my brother. I'm a younger brother.
Yeah, you know what they have done for them. I remember when we went to the country. Ask him. I called him, and he was prepared to go to the news file to explain what obtains at the various faculties and why people should pick and choose and put their wards and children there to study law, not any faculty without lectures and whatever. And yes, the bench approached you, and you did it for us for free. Yes, so these are some of the things that we can all, do to help the profession. It's nothing more. Yes.
So we are really grateful, and thanks for.
And just one more thing from me, Mr. Dr. Aine, as a former Attorney General, I have sat with you on the Judicial Council before. The two of us have joined to even appoint justices of the Supreme Court. You know the challenge, the difficulties, what we went through to appoint justices of the Supreme Court for this country. So after serving the Republic in that light, it seemed proper for you to go and make those statements to give the impression that the justices make decisions based on certain things. That's why some of us are disappointed at that statement. But having rendered this apology, we know, as my brother Justice Apau said, sometimes out of some kind of excitement or so, you are forced to make certain statements. As we've said here, we all make mistakes. We are human beings, and once in a while we cross the line, we make mistakes. So I'm happy that at least you've realized that what you said was overboard and you are prepared to retract it. But going forward, let's remember that we have one country and we all have a responsibility to keep this country together, no matter the circumstances and the situation we are confronted with. Thank you.
Lord, we are grateful for the admonition. I promise you, this will not recur. I'm grateful.
Yeah, my court.
Yes, my Lord, with all due respect.
Yes.
My Lord, before this matter commenced, your Lordship mentioned my name. My Lord, with the greatest of respect, with all respect to this court, I just want it to be placed on record that I have not said anything to scandalize this court. I believe that...
I didn't say so. What I said was that when we started the proceedings, you were granting interviews, and we drew your attention to the new legal profession ethical rules. Yes, we drew your attention to it, and you were advised to stop, and you did.
My Lord, your Lordship, I no doubt dispute that.
Yeah.
But I think before the proceedings,
I never said you.
Something was said to that. Myself and.
Yeah. And
my Lord, if that is the position of the bench, yeah. I'm exceedingly grateful. I don't want my name to be associated with scandalizing this court. As a former president of the Great Accra Bar, the longest serving president of the Great Accra Bar.
And the most populous bar.
Yes, and the most populous bar, arguably. Justice Amigache is not looking at me. I was the Mugabe of the bar, and I remain so. Yeah. I'm grateful.
Yeah.
I'm grateful.
I thought you were the Nkoswaini.
Yes, Prof, you can call me that. That was conferred on me by the Sanzini Amisha as a custodian of the bar, so I still remain.
And we take this opportunity to also thank you for your end of year dinners for the bar. For the bar and the judges.
So far as that is concerned, Justice Apo can bear ample testimony.
So thank you.
With my eloquent service of blue label Scotch whiskey.
Thank you. Yeah, thank you. This is the order of the court. We accept the apology of learned counsel for the contempt law. We, however, order that the contempt law purges its contempt by retracting the scandalous statement on the very same medium before Thursday, the 25th of February 2021, when the court will reconvene. The contempt proceedings is thus adjourned to Thursday, the 25th February 2021 at 9:30 a.m. So, Mr. Bicham, so you will come here 9:30. If he renders the apology, we will come and completely vacate the order.
My Lord, just for some clarification.
Yes.
I don't believe we are expected to be here on Thursday. No, we just want to be, yes. Very well.
If you want to come and show solidarity, you are invited, you are at liberty to attend.
So.
Rise.
Networks across the country, and on Facebook, Ghana Broadcasting Corporation. The ruling has been given finally. The review for reopening the case has not been approved and dismissed, and part of the phrasing there says that it lacks merit, and so that's it. And finally, the court has given the 4th of March 2021, this was next week Thursday, for judgment.
Yeah, so we're still here in studio, and we've been joined by Dr. Ajiman Budu. He's been here all through the process, helping us understand the very details of this particular election 2020 petition hearing. He joins us once again. Good afternoon to you, Doc.
Good afternoon.
Right, it's been interesting in court. By way of telling us what's happened, can you just briefly take us through what's been happening after we went for that break?
All right, so the first thing that happened was that the court gave its ruling, and until we have the certified true copy of the ruling, we will not be able to delve into detail, because we just heard the Honorable Chief Justice read out the ruling. But from what I heard, the ruling was to the effect that the petitioner had failed, first and foremost, to indicate the nature of the subpoena and the type of evidence that was to be adduced. And so the application was dismissed as not being supported in that regard by any law and settled practice. The court went ahead to set out or suggest that they had set out the boundaries in their 16 February ruling, the boundaries that must be complied with if the court were to or was to exercise its discretion to allow a party to reopen its case. And so they proceeded to set out the 6 grounds of review which the petitioner set out as occasioning a great miscarriage of justice, and proceeded to deal with them consecutively. So, for instance, the court disagreed in its ruling with counsel for the petitioner on the alleged fundamental errors that the petitioner was alleging the court had engaged in, and reiterated the fact that they were the highest court of Ghana, and their decisions are binding, their decisions of law are binding on all other courts in Ghana. And so they talked about also the interest of justice not being only the interest of one party, but in order to determine what is just regarding the duties of the parties in that particular suit. And so they set out the threshold once again that you need to meet when you have voluntarily closed your case, and then proceeded to deal with the issue of Section 26, the issue that had to do with the conclusive presumption that the petitioner was alleging that by virtue of statements or averments in the positions deposed to by the chairperson of the Electoral Commission, suggesting that the interrogatories or the questions contained in the application for interrogatories that the petitioner sought to say.
No, just kind of hold on for us. We'll go for the press conferences from the two parties, and then we'll get back. So let's quickly move back to the forecourt of the Supreme Court for the press conference.
The country that we have. What the country that
There's a certain page I have marked.
Okay.
28 since April. Please, are we all ready? Okay. Good afternoon, distinguished friends from the media. As always, we are grateful to you for the opportunity to address the nation and by extension the world on the court's proceedings on the 2020 election petition, a matter which is of considerable public interest. Several things happened in court today. But the first was that counsel for the petitioner moved an application for leave or an application for review of the court's decision on 16th February, which is the court's decision on our application for leave to reopen our case so that we could subpoena the chairperson of the Electoral Commission to testify. Now, for those who are not lawyers, an application for review is a right given to any party dissatisfied with a decision of the Supreme Court to apply to the court and invite the court to respectfully review or change its own decision. And Article 1331 of the 1992 Constitution and the decisions of the Supreme Court has made it clear that you can apply for review of the court's decision, and in fact the court will review that decision where there are exceptional circumstances such as fundamental errors of law committed by the court which have occasioned a miscarriage of justice. And so today's application for leave that counsel for the petitioner moved was to achieve just that, to demonstrate to the court that in this decision of 16 February, certain fundamental errors of law were made, and to invite the court to remedy or rectify those errors by reviewing its decision in the interest of justice. Now, the grounds that counsel for the petitioner relied on in moving this application was that, one, you would recall that when counsel was moving the application for leave for the court to allow us reopen our case, he was asked in what capacity he was seeking to call the chairperson of the first respondent, and he answered by saying that the petitioner was going to call the chairperson of the first respondent, the EC, as an adverse witness. And so you would recall that in the court's decision, the court stated that in their opinion, it was wrong for counsel to have said that he will be calling the chairperson of the first respondent as an adverse witness, because per the Black Law Dictionary, a witness can only be described as an adverse witness after the witness has entered the box. And if it is detected during the evidence in chief of that witness that he or she is giving evidence adverse or contrary to the case of the party examining him or her, then that witness becomes an adverse witness, and counsel can then apply to the court to treat the testimony of that witness as that of an adverse witness. That was the decision of the court. Now, ground one of today's application argued that that decision of the court was a clear fundamental error because it did not take into cognizance Section 72 of the Evidence Act. Section 72 of the Evidence Act is simple. It says that subject to the discretion of the court in a civil action, a party or a person whose relationship to that party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination. And so if you are a party or you are a witness or any person and your interest in the case is substantially the same as a party in that case, then an adverse party can call you to give evidence. And so in our respectful submission that we made to the court through counsel for the petitioner, one does not have to enter the box before that person can be described as an adverse witness. And that Section 72 of the Evidence Act allows a party to call a person whose interest in the case is substantially the same as another party in that case as an adverse witness. And so for us, the court's decision for this reason was per incurium. Per incurium basically meaning that it was without recourse or it did not apply this section. And for us, this is a very serious fundamental error because as the court itself has held in several decisions, the court is the servant of the legislature and must apply the rules or the laws that the legislature, passes. Then secondly, counsel for the petitioner argued that the court committed another fundamental error of law when it stated in its ruling of 16th February that Section 26 of the Evidence Act is inapplicable. It wouldn't apply Section 26 because of Order 38, Rule 3E5. And just to break this down so that those watching can understand, counsel for the petitioner has argued, and we have explained or elaborated that point here on several occasions, that for us, Section 26 establishes the principle of estoppel. And that section basically says that if through your acts, statements, or omissions, you intentionally and deliberately makes another person to believe a thing to be true, then the truthfulness of that thing must be conclusively presumed against you, that person having relied on that representation from you. which basically means that if per your actions you make me believe that you will do something, and I rely on that, the court should not allow you to resile from that position. And we have explained that. We are saying that G. Mensah, through her depositions in at least 2 affidavits before the court, made it clear that she will be available for cross-examination to answer certain questions. And so she's bound by Section 26 under the rule of estoppel to change her position. And in that ruling, the court said, because of Order 38, Rule 3E5, we will not apply this. And we, today, counsel for the petitioner respectfully submitted that that was a fundamental error of law. Because number one, Order 38, Rule 3E5 has got nothing to do with the principle of estoppel and a witness or a person being, being held by the court as bound by a previous representation. That order has to do with a party having the right not to call a witness who has already put in a witness statement. The purpose for us relying on Section 26 had nothing to do with the party. It had to do with G. Mensah as a person. And so for us, that was completely irrelevant. And counsel for the petitioner further argued that even if there was any relationship between Order 38, Rule 3E5 and Section 26, Order 38, Rule 3E5 could not be interpreted or construed as having precedence over Section 26, because in the hierarchy of laws, a constitutional instrument is subservient to an act of parliament, and Section 26 is provided for in the Evidence Act, which is an act of parliament and which is superior to Order 38, Rule 3E5, which is a subsidiary provision in made by the Rules of Court Committee. Again, counsel argued that the court did not take cognizance, or the court did not apply Order 38, Rule 10 of CI 47, which counsel indicated to the court that he was going to apply should leave be granted for the petitioner to reopen his case. He said, I will follow this rule, Order 38, Rule 10, which is basically the rule or the process for the issuance of a writ of subpoena. And that the court's decision did not make any reference, not only to Section 72 of the Evidence Act, but did not also make any reference to Order 38, Rule 10, which we had indicated that we were going to rely on to subpoena Mrs. G. Mensah. Then he spoke about Article 19.3 and Article 296 of the 1992 Constitution. And Article 1913, has to do with an adjudicating body acting independently, impartially, and ensuring that a case brought before that body, is conducted in line, fairly, in line with a fair hearing. And in our opinion, counsel for the petitioner submitted that if you look at the way the court has failed or refused to apply certain statutes, and the court appears to be shielding, in fact that is in his statement of case, shielding the EC chairperson from accountability or testifying, it is not fair, and it violates the petitioner's right to a fair hearing as stipulated under Article 19, Clause 13 of the 1992 Constitution and Article 296. And the question we always ask, which we would like to reiterate today, is that why must we go through all these tedious processes just to get a public officer who we pay as citizens of this country, a public officer who has discharged a certain constitutional duty by conducting elections and declaring the outcome of same? We are talking about G. Mensah, the returning officer for the 2020 presidential election. Why must we go through all these hassles, all these troubles to get this woman to just give account of her stewardship, how she did her job, and how certain things happened, so that the courts can know the truth in these matters and do justice? If she has nothing to hide, if she has done nothing wrong, why must we go through all these tedious processes? Now, there were questions about, where you close your case voluntarily. Yes, we close our case based on the representations of the EC chairperson that she was going to be available for cross-examination. And at the time we were closing our case, we could not have subpoenaed her to testify because she had filed a witness statement and several affidavits which had made it clear that she was going to testify for the first respondent. And so the law and the rules of this court would not have allowed us to even subpoena her at the time. So this issue of, oh, you close your case voluntarily, you cannot, no. Last time, the president of the bench stated clearly that it is a settled principle of law that a party can apply for leave to reopen his or her case after he has closed his case. And that is what we have done, and we believe that we have demonstrated that the circumstances or the conditions which are important for such, for leave to be granted in such circumstances have been demonstrated. The court dismissed this application and said basically that we failed to show the reasons why we were seeking to subpoena Madam Jean Mensah. Now, because of time, I will not go through our statement of case and all that, but you can check paragraph 28 and paragraph 42, and you can see for yourself that counsel for the petitioner and the petitioner explained clearly why we need Jean Mensah to enter the box. We explained that she is a returning officer who made a declaration of 9th December. It is she who claims to have made errors. It is her outfit which purportedly sought to rectify that error through unlawful means. It is this same returning officer and her office who have sought to churn out conflicting and inconsistent figures. And that it was important, among other things I would say, it was important that she be made to enter the box, cross-examined, so that the truth in these claims could be unearthed for Ghanaians and the court to appreciate all these things. So we disagree with the court that we did not show why we are seeking to subpoena Jean Mensah and the usefulness of her testimony to the determination of the issues before the court. We believe that the evidence before the court shows that we did that. Again, the court, in interpreting section 26, commenting on that, said that, oh, there are certain conditions when it comes to promissory estoppel. Now, it's instructive to note that counsel for the second respondent, lawyer Kutampa, had suggested that Jean Mensah didn't even make any representation to us that we could have relied on. And that what Jean Mensah did was basically to state the position of the law that she will be available for cross-examination. That was not a representation, was not an undertaking. Those were his words. Now, the court in this ruling says that it is a representation, but same cannot be said to be unambiguous. In other words, it is ambiguous. We have read those depositions over and over again. Those depositions are undertakings. Per section 26, Jean Mensah is bound by same, and there is no ambiguity in those depositions. She says clearly that the petitioner will not suffer any prejudice or injury because the petitioner can solicit the answers he is seeking through interrogatories during cross-examination. And we believe she meant what she said. Before I conclude, again, the court spoke about section 72 of the Evidence Act that counsel argued on in this case. And the court said that there is no inconsistency between the Black Law Dictionary decoded and section 72. Yet the court still stands by its definition of who an adverse witness is, that a person must enter the witness box before he or she can be described as an adverse witness. Clearly, you can all download the Evidence Act 1975 and read section 72 for yourself. It says that, among other things, a person whose relationship to a party makes his interest substantially the same as a party may be called. So you can be called to enter the box as an adverse witness. You need not be in the box before, on the basis of your adverse testimony, you are described as an adverse witness. And so there too we disagree with the court. But ladies and gentlemen, a lot happened today. We do want to bore you with all the details. The bottom line is that the petitioner is worried that the courts, in deciding these applications, are not applying statutes that have been passed by our parliament, and statutes that the court has been applying in other cases. And we think that the petitioner is being denied a fair hearing, and it is important that these issues be pursued to their logical conclusion. Now, why are we doing all these things? We are doing these things because of the constitution that all of us as Ghanaians have agreed to be bound by. Article 63.3 of that constitution says that no person should be made a president until and unless he attains more than 50% of the total valid votes in any presidential election. And it is clear from Jim Mensah's own declarations and the figures contained therein that candidate Akufo-Addo did not get more than 50%. We've done the mathematics here over and over again, and you can do the mathematics yourself. He did not cross. And so the petitioner, John Dramani Mahama, His Excellency, is doing this for and on behalf of all of us, and he's doing this in defense of the Constitution. And so we must all be interested in this case. Let me appreciate those who have been encouraging us and cheering us on. We really appreciate your encouragement. And we are assuring you that we are not giving up, we are not giving in. We are fighting this matter in the interest of justice and for God and country to its logical conclusion. So that tomorrow, an EC chairperson or an EC will not arrogate to themselves the power to choose leaders who have not met the constitutional threshold that we have all agreed to work with. We don't want that bad precedent to be set. The will of the people must always hold sway over the will of a select few. And for those who are crestfallen, those who are discouraged, and sometimes call us worried, disturbed, why don't you withdraw this matter? Why you shouldn't even go to court? We want to tell them that we understand and appreciate your frustrations. We understand and appreciate that. And we are telling you, don't give up. We are not doing this for nothing. We know what we are doing. And we are doing this because of the love we have for Ghana, particularly that of the petitioner. And so let us all be patient with the legal team as we go through the process. We are not abusing the court processes like some are suggesting, and we have not defied the orders of the court. Everybody knows that any party dissatisfied with the decision of the court is entitled to a review. And so we are just using processes provided for under the laws of this country that we have all agreed to be bound by. And let me just say finally, like I said last week, that no matter how this case will go, no matter how the decision will go, because we are all discerning, because we all love the truth, because we are all following this case keenly, the truth will become clear to all of us and we will all see the truth. And don't always think that when people come to court and the applications are dismissed, it means they are wrong. No. What it means is that it is right for the time being and it is what the court has said that will prevail. Like now we disagree with the court, but whether we like it or not, what the court has said is the law and that is what will prevail. But posterity will be the judge of us all. Just like it happened in the case of Ray Akutu, when the Supreme Court then unanimously dismissed the case brought before it by Joseph Dankwa, J.B. Dankwa, with regards to the unconstitutionality of the Preventive Detention Act. Today, even though the court held in that case unanimously that the presidential oath was akin to the coronation oath of the Queen of England and didn't constitute a Bill of Rights and all that, today, what is celebrated is not the court decision. In fact, that is the most unpopular decision in the history of this country, even though it was a unanimous decision. What is celebrated are the submissions of J.B. Dankwa. And we believe that posterity will judge us very well. Will judge us very well. We are hoping, based on the indications that the court has given, that they may find it necessary for counsel to be given the opportunity to make some submissions, oral submissions, on the written submissions they have been asked so far. There's not been any clear indication to that effect that will be done, but the court says that if it finds it necessary, the court will do so. We think that looking at the considerable public interest in this matter, it will be important for that to be done. But if the court, in this wisdom, decides that they are not going to allow counsel to make any oral submissions, we will respect that, and we will be engaging you in the media, and we'll be sharing with you the content of counsel for the petitioner's written submissions. And so that's where we'll end it. If you have any questions, you can ask. Of course, in 2013 it was done. So we are hoping that that precedent, which is a very good precedent, will be repeated in this case.
Thank you. Two quick questions. The ordinary bench and the application to reopen, a 7-member panel dismissed the application. We have an enhanced panel, 9-member panel, equally dismissed the application. Obviously, from what you have said, you are dissatisfied with the decision, but you have to file your address anyways, and you would have to do that, close the case, file your closing address without the benefit of the testimony and cross-examination of the EC chairperson. Question number 1, are you disappointed? Question number 2, is the NDC going to be seeking another opportunity to hold her accountable, as has been the talk all throughout?
Okay, so the first one, are we disappointed? Yes, we are disappointed. We are disappointed that, in our opinion, the petitioner is not being given a fair hearing. We are dissatisfied that, in our opinion, it appears that the EC chairperson is being shielded. We are dissatisfied that, in our opinion, and as articulated by counsel for the petitioner, known principles of law and statutes that our parliament has passed, that the court has previously applied, are not being applied to this case. So, in our opinion, we are not being treated fairly and we are disappointed. But the decision of the court is what prevails. And to answer your second question, are we going to explore other opportunities or avenues to hold her accountable? Emphatically, yes. We will explore. We mean it when we say we will explore all options and fight this matter to its logical conclusion. Any other question? Okay. So, Baba will do this.
Yo, anyone, I say, ne court by no, in some you know, and a see or court her. Yedi kind, I say, a system for a tree, court to see Jinaebi. Jinae see in his own my own quite me, yasem. Send a bay bet me a frame a major mensa. Now about a becan and nuns and watch and ye see or abatunum. And nay, some by say, courtroom san Henry Jina Enebium. A son say, Yea, you moody and some major mensa, one man who crows a me, or no. Anna or declare election, or no, and or my figures different, or no, and or threaten and Kuvad Winia, yea, Yensus Yemuni and Kunda Bumuno, Nana Kuvad Wayna 50% plus one Wayna. And it's a Baba Casam, Naso or no ma Amakabidia, not just as some Nakano, na a refail. Ye Kayanumun Sambiara, and so court no any anyading, court no any and say. Ono de ofose ma meji mensa ba enye saa semi ene asem wesi o court na ye ne ye gusu agina bebi agina se court na kasa de na ne court mu so beka ena ye mra be no so nkyere se be sa woni court na adwen a wontimi nka wasem eye minu akasa no oma decision bi a emre bi court na si agina ya court nipa na wo hoyi na aka se ni oma kan na enukure na nsi ebe chire no na asem no asesa endi ye didie mu de enim se asem na ekono ne court kan ye no wa kan de na ye nso ye no mu ya adwen ye be se ye Ghana fo ina bo se ne ye no enya se ye no kwa ye ne si enim ne ye Don Dramani Mahama wotunu wasi ho so obaboa mu obiara court nsema wa kan obi atiase wetu no wagina wo se no kura wo sasem no mu e wo se pie enti se obi gina ho no kasa bi o adentina mo koso ye adentina mo nya ne pese obi ati ase ne se Don Dramani Mahama ogusu gina bebi ogina ne ebeye biara kwan bi foforo bia wo ho na o se faso mama me no beka na num nsem ma no kura no de di magana 40 a inshallah ye do mbeba. Assalamu alaikum jamaa. Yau kuma mun zo court inda muka zo court abinda muka gani yau shine matan da ta saya aka yi wanga takara, matan muna so ta zo ta shiga cikin takaran, ta shiga cikin adaka ta yi magana mun yi court wai bai rayu da mu ba. Amma abinda muke so jama'a su gane ba wai ka zo court na ka yadda maganan ka ya kare ba. Akwai hanyoyi da yawan da za mu bi ba kuma abin da za mu bari ba. Za mu ci gaba inda za mu bi matan ta shigo ta bari jama'a su gani gaskiya a me ya faru domin ita ta zo ta yi declaration nan ita ta sai aka yi takaran abin da aka yi duka ita ta yi to don me za zo yi magana a ce babar ta shiga a daka don me za zo a kawo magana ta ce ba yadda
Yau mun zo court wai bai yadda da mu ba, amma abinda muke so mu gane in court bai yadda da mu wannan bai gwada kuma magana ta kare ba. Za mu ci gaba inda za mu bi magana ta kwanta, matan ta zo ta faɗi gaskiya ko yau ne ko gobe ne ko zuwa gaba ne, za mu bi mu bar ta zo ta yi gaskiya. Assalamu alaikum.
Please, Dr. Ayine will address you briefly. So.
Madam, we stand by.
Let's all stand by him.
He's coming.
Okay. Thank you.
I'll stand beside you.
Okay. All right. Yeah. Let's okay. All right. Good evening, ladies and gentlemen of the press. I am here this evening in respect of the remarks that are made to you on the 16th of February after court proceedings. Those remarks were widely publicized by the media, and both mainstream and social media carried them and they went viral. I have looked at what I said that day, and I have come to the conclusion that I went overboard, I crossed the line with respect to the remarks that are made in terms of attributing impropriety to the Supreme Court of the Republic of Ghana. And I just wanted to let you know that this morning I delivered a letter to His Lordship, the Chief Justice, offering an unqualified apology to the court. Now that letter has been filed and the Chief Justice of the Republic has referred to it, I want to take the opportunity to read the content of that letter to you, and thereafter I will apologize and retract my words. Now, the letter reads, My Lord Chief Justice, summons to show cause unqualified apology to the Supreme Court. On the 16th day of February 2021, I addressed a press call at the premises of the Supreme Court in respect of a ruling that the court had rendered on that day. I did so in my capacity as a member of the legal team of the petitioner, with instructions to brief the press on matters of concern to the petitioner after court proceedings. In carrying out my instructions on previous occasions, I had always made certain that I explained the day's proceedings to the understanding of the press corps and of fellow citizens with civility, and without seeking to attribute acts of impropriety to the Supreme Court or the respondents. On the said day, I thought I had maintained that approach to the press briefing, but on hindsight, I actually crossed the line in suggesting that the court had a predetermined agenda, among others, to rule against the petitioner. My attention was drawn to this fact immediately after the press briefing by Frank Davis, Esquire, to whom I am grateful. It was not my intention to scandalize the court or to bring it into disrepute. In the circumstances, I wish to apologize unreservedly to the court. Yours sincerely, Dr. Dominic Akuruting Ayine, signed. And for those of you, I'm sure Mr. Frank Davis is not a stranger to the press. He's standing here to my right. I remember on the 16th of February when I finished addressing the press, he walked up to me and reminded me that the phrase that I had used, that there was a predetermined agenda, had crossed the line. And that is when I started thinking about whether or not I had crossed the line. And I agree absolutely with Mr. Frank Davis and those of you who think that I crossed the line on that day. I wish to unreservedly apologize to the court, that is the Supreme Court of the Republic of Ghana, as well as the justices in particular who sat on that day. There was no intention on my part to impugn their integrity. I was just expressing a sentiment with respect to the ruling of that day. And I want to render an unqualified apology and to retract
the words that are used on that day in their entirety.
Unreservedly.
Unreservedly, I will not in any way want to disparage the Supreme Court of the Republic of Ghana. You can see I'm lost for words because I don't want to be, when you want to take a pegative, I was told that I should peg myself of the contempt. So you take the pegative so that you don't complicate the constipation. So I'm being very careful that the pegative I'm taking this afternoon will not complicate the constipation. And so I wish to thank the press for the opportunity to address you, because His Lordship the Chief Justice, in making the order, said I should use the same medium that are used in conveying the words that are the subject matter of the contempt proceedings. And so thank you very much, ladies and gentlemen of the press. I am hoping that my apology and retraction will be accepted by their lordships, and the matter will come to an end. Now, in respect of this matter, I plead with the press that I won't take any questions and provide any explanations. God bless you, and God bless our homeland, Ghana. Thank you very much. Thank you. Okay.
Colleagues, good afternoon. We'll make it pretty snappy because we can tell that you have a big story today, bigger than all that has happened in court. So we'll make it pretty snappy. I think you have followed for the several hours of today the legal arguments that were made by counsel for the petitioner, and then responded to by counsel for first respondent, counsel for second respondent. I think at the end of the matter, I want to draw your attention to the words of the Supreme Court speaking through His Lordship the Chief Justice in ruling. And I want to focus on that because lawyers express their opinions on the law, what they think the law means, what they think a proper construction of the law ought to mean. And I think today you are noticing that our friends on the other side now keep using the phrase that in our opinion, in our opinion, in our opinion. Initially, the argument was as though it was fact. But you notice that the point is being made that people express opinions, the court determines in the end. The court has said that the legal arguments, the provisions of some of the acts and the CI and some of the authorities that the petitioner's legal team tried to invoke, together with the principles of equity, and if you just listen to the court, it says that the positions that they were expressing are not supported by the law or the principles of equity. So even a reiteration of it before the press and a re-explanation does not change the fact that the law does not support the position that they've been expressing. And so we will not go into a reiteration of all the legal arguments that we made. I think this is about the third time that the court has dealt with this type of issue and has come to a certain conclusion on it. The court also says that they did not satisfy even the minimum threshold required to sustain an application of this nature. You know, sometimes when we make this point, it appears as though we ourselves are saying it. We are not the ones saying it. The court, I think this is the third time that the court has made the argument that the law does not support their position. They have not met the legal threshold. So we are not the ones saying that what they are saying does not align with the law. For someone to say we are disrespecting our seniors, etc. The court, the Supreme Court of the Republic of Ghana, is the one that is making the point that they have not satisfied even the minimum threshold. So we won't bore you with too much detail. The court has decided that on the 4th of March, judgment should be delivered in this matter. This is after the petitioner who came to court, among other things, arguing that nobody won this election, has called 3 witnesses, and has now, I think in the last 2 or 3 applications, been praying the court to literally force the EC chair into the box so that he can reopen his case and advance something else which he hasn't told the court, something else that can help make a better case for him. The court has decided that despite its earlier warning that if its processes are not complied with, it can strike out the matter, it will still accommodate them so that they can file their written addresses. I think this is clear evidence that nobody's being denied a fair trial here. The court has bent itself backwards and is accommodating the interest of all parties. So we look forward to the 4th of March for judgment. If it is the view of the court that they want to invite our lawyers, viva voce, to address some issues, they are more than prepared so to do. But Ghanaians have followed the journey that has gone on so far in the courts, where the petitioner was being looked to adduce the evidence. I heard our colleagues here saying that the mathematics is clear, but you have been here covering for all the days that we have been here. And I'm not sure that to you, you saw mathematics that yielded results other than 47% for the petitioner, Mr. John Dramani Mahama, and 51.2 for the second respondent, Nana Addo Dankwa Akufo-Addo. That was the mathematics that you saw Mr. Johnson Asiedun Ketia arrive at. That was the arithmetic that he arrived at, the answer that he arrived at when he did the various computations. Today you are hearing them telling you that the mathematics is clear, is nobody crossed the 49%. But in the wells of the Supreme Court, before the justices, and I'm not sure you have seen them prove that. But in any case, we'll come back on the 4th, and then we'll stand by for judgment. So we'll keep it simple. We'll take your questions, and when I'm done, my colleague Nana B will do a quick Twi translation, and then Faisal will do a quick Hausa translation for us. We're going to take your questions.
Sami Jenfi stated that after this proceedings, if unfortunately the ruling goes against them, they're going to use any other institutional measures to still bring out the fact that they need from the EC chair. I want to ask, are you also ready to counter all the...
So for those who didn't hear the question, his question is the admission by the petitioners team now that they are willing to explore other avenues for the so-called accountability and truth that they talk about. First of all, let us reiterate that the truth is what has been laid before the court. The truth is what has been gazetted. That Nana Addo Dankwa Akufo-Addo, when you add the 38,000 plus polling stations, or you add the 275 constituencies, or you add the 16 regions, the truth is that Nana Addo Dankwa Akufo-Addo crossed with over 500,000 votes as a margin. It is the petitioner who seeks to challenge this truth, but has not brought his truth to court. Whatever counter evidence that he may provide to cause even the chair of the first respondent to get into the box, I'm not sure you have seen it here. But today they are admitting before you that they are willing to explore other avenues of accountability. Remember, about 2 weeks ago, we've been arguing before you that if you want accountability, generally, you can come to Parliament. The parliamentary committees of inquiry that can look into whatever matter you bring, and there's a 137 plus 1 Parliament. You can come to Parliament. You can come under the Right to Information Act asking for some particular information. If it's judicial review that you want, that you think that the EC has not done something specific and the courts must bring its power to bear on it, the high courts are there for judicial review. So it is interesting that at the end of the case, when we are all wondering where the evidence that they were supposed to provide to back their case is, they are now opening up to you that they are willing to consider other platforms of accountability. We'll see which ones they choose, what case they make, and if there's any adverse arguments that need to be made there, we'll respond accordingly. Are there any other questions? Like I said, we know the big story that you have today, so we won't bother you with too much talk. Nanabi?
Yes. Abushanfo ene omana de share
Ebedamasi, Senya Minia Kojo upon Kroma Abo Nitofano, Saana Minsumikrano, a pot bear inum. Nia Edikai Mubakaya Nano, and I could do both 42 just say, Enka Omasama Nanka, Omatumu Epuno, no Mabomun Crow in a na omon sem ni nyina no mo se omaka amanasa oma dance fo enso asa ekowie achi no mo se awose ye twe maami Jane mensa ebegina adaka mu ansa na omasem no asipi na asita anunti omo pe ekwan afri court ho court mo omo kwan no mu mie omasem nani no mu bi omasem nani nso a Omasade at court anim sa court enhye maami Jane mensa na omegina adaka na yentoto na no obakaya eno court empanimfo nso nyina omadwen ekọ benkrom ema omoka se dabi enya ade ombema kwan amakọ adubofo e petitioners no omabie omasem nani eno achi ena asem ebeto odwane se omosade adesede sa beto eye Supreme Court anim se asamo na no omo kan se nkomo makwan emom mbio masem nani no omo sere omo san sakra omadwene san se emra bi ho no a omo amfa anya adwuma ene court achirechirem se ansana obeba Supreme Court se omo sakra omadwene no enye kwa ena enye se oma oniema so anu abase yen sakra yasemani awose wo kire se na ade poten ade sonko ade nwanwaso bi wo hono a wonsanka ebra na yedi asem no na saa ade nwanwaso no ama tentene eni pepepe yo akadwam eno kwadubofo na ntimi ankere na ye nanu komobo na omo kan na eno ano mo saka dada no a asem fufuo bia eni ho eti court esa akoy obekaya ye ne empanifo mienu sa beka ho mo ye nkono empanifo nkono nyina se asem a mo de ba ye no eni nyina so emramu ye nhu ye enu ntino ye ntimi ema mo kwan ma mo nsam bie mu asem nani na emom nyame ya adom a ya hye busumi a eba be wrami eda etoso 9 4th March ye de yatemu eba entino obibia anko na abekai so a ade ba ko na kodubofo ne kampa na medi twato ene se court betie na court tetie omuye na omu nsam omu wonyina no ombetimi aka ne emramu ye fe no fair trial abusiam bekaya ye hye asem ne yasi court tetie asem ne ye pa ebra omu ye mfomso kra omu kratam court mo kwan mo kosiesie de bae aye ensemfo no mo so beso mo de pimpim easy ye mo kwan yetie yo mo applications ahodo mo de ababeto court anim court etie yo mo se okinkan a applications a mo de abeto court anim eye enson ni nyina court no aboagu sanse omasem no eni nyina so etinyame ya adomo a ye sai be hia e wa ha sei busumi a ebewuramu eda etoso 9 na asemo aya na metatie eni se yenuanu mandisifo omunya rehemu sanse asemi de ekoye mesre so muntimi omade so a momo mfa nhye omukahiri anano pay mekaise mitie openi baako alaji nu safuseni ndc ni mapa oso no kwa wapaba sanse asem no ensuo bia enyinam tebusuanfo medam ase na ansa na menua feza de hausa de no bebrem no mese ne mpanifo abekan ye ho ene ye nhye bia ma gise 4th March nti mo fama so mfemme ye chairman ye pani audi anim chairman makmenu ene okan ye ho ha aya ono ana sa ye star witness on ejine mu ma omampani na adodankwa ekufu ado lawyer Joyce Opokubuaten nso ekan ye ho e wo ha sei ana Hajia Fatimatu Abubakar Esquire or a lawyer ni mapa ansana mia minua kwadwo pon kroma minister designate information okodada ena ebiemu nso Nanajua Adobia Asante Kati, Mrs. Enzo Akayahu has a lawyer. And now, Evans Nimakon, Director in charge of Elections and Research. Penny Bako, Director of Communications, or now said lawyer Nimapa. Osaka Kasama for lawyer Ya Boaben Asamwa, and so Akayahu ha. A BM Patriot Fraser, and so a lawyer Nimapa, no so Kayahu. Lawyer Lenin Akayahu. Ya lawyer for Unkumo Muso Boa Research, and so Kayahu ha. Lawyer K. Amwa, and so Ejna Cheho. And Sana Niamate, and so Ewa and Chenwaha. A BM, the president's lawyer, lawyer called Esuman, and now lawyer Hajia Hamida Nuhu, Omunya Kayonha, lawyer Akutampao, lawyer Frank Davis, lawyer Sheila Menkampremo, lawyer Kwekwe Srifi, lawyer Yao Opon, lawyer Yao Ado, lawyer Victoria Bath, lawyer Ochri Ejekum, lawyer Dr. Ernest Owusu Dapa, and now your head of technical team, the fearsome and the intelligent Joe Anoche. Nyamishamo, Patriot, Rabbi Janefa House and a bomb.
To Yawaina Nafara, the Gaiswa Mekanshi, Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Yawadamko Zo Court, Abinday Hapkuni. Lawyers for John Dramani Mahama, Sukazo, the Abbas Anya, and so the kids. To Nakaiku, Baya Kadang, Bayan the Muka, J for Korea, December 7th. The Electoral Commissioner Tafto, Tabayana Resource, Shea and the Sukazo Skate answer to elections the Muka Yinda. Suskate Kama, Susukachi, Ukutuna. Wara su kaman pita otukuno sun fito har sun ba da figures the percentage da ke gwadawa kaman sun ci elections. John Dramani Muhammad da kanshi shi ma ya fito ya ce election da aka yi ya ci. Sami Jemfi kuma ya fito har shi ya declare John Dramani Mahama kaman shi ne president elect. The general secretary su Asedu Ketia kuma shi ma ya fito ya ce kaman elections da aka yi su suka ci. Amma da suka zo court she suka sake bakin su suka ce a'a ba su ci ba, amma election da aka yi nan ba wanda ya samu more than 50% of the valid vote. Bi mana in aka raba vote da aka yi, in aka raba cikin biyu ba wanda ya samu more than 50%. Isa na befi a declare President Nana Addo Dankwa Akufo-Addo president ba. Da suka so suka file wannan petition she haki yazo kansu domin in kai ka ja wani ka zo court kai allegation kan me shi ya fi ka kawo hujjanka da shaidanka da ke gwada kamar allegation da kai nan gaskiya ne, to shi the court zai duba ya rule ibaka. Amma da suka zo suka kawo shaida guda uku, witnesses uku, Asedu Ketia, Dr. Michael Pesawite da Rojo Metodunu, da suka zo maganar da suka yi da suka shiga cikin adakan bai gwadawa kamar allegation da suka yi na akwai hujja ciki. To shi lawyer su ya tashi ya ce ma court kamar shi kesin ya kare kesin shi. Shaka tambaye shi ka kare wai na kare kesi na. Aka ce in ya kadan ni court ya bada anya kamar EC da team president Akufo-Addo mun bude kesin mu. She muka ce in ka duba evidence da suka kawo, hujjan da suka kawo bai gwadawa kaman sun justify allegations su. Isa inda kana ne mu dai ba mu kawo mu namu. To shi lawyer kuma ce bai yarda inda kana ne yana neman a sa ma EC ce igiya wuya an so a jawo ta a kawo ta a cikin adakan. To shi court ya ce bai yarda, shine yau suka file for review. Yau kuma court ya gwada kaman a'a ba wannan anya. To wuri muka kai yau court kuma ya bada date 4th March in aleke mu da mu zo a bada final judgment. Isa in aleke mu on the 4th of March mu zo danga an so mu zo mu ji final judgment. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
Those were the two press conferences, and of course we also did witness that apology rendered by Dr. Dominica Wijayini. But let me quickly remind you what happened in court today. First of all, in court today there was the hearing of the application by the petitioner for a review of the court's decision which was taken on the 16th of February. That decision which had to do with the petitioner applying to be allowed to reopen his case. Of course, the decision of the court was that the petitioner, that application was dismissed by the court. Then the petitioner's lawyers then appealed to the court to review that decision, which is what the court considered today. Of course, lead counsel for the petitioner, Mr. Chatuchikata,